So we've got a new UK data protection reform bill. I want to have a little look at what it's for and whether it achieves the aims that it sets out to achieve. It's 206 pages long, though, so I'm not going to haul you through it page by page. It's not, in my view, a page turner. I'm going to give you 3 visual clues to how I reacted to it as I read it. Just to orientate ourselves, this is a bill that will replace our existing legislation if it comes into effect. It was brought in last summer in July. It was quietly shelved when we had that budget fiasco in September. It re-emerged as Data Protection Bill number 2 in March this year, and it has just only yesterday finished the report stage in the House of Commons, which means it goes to its 3rd and final reading in the Commons, and then it goes through to the Lords. And the political rhetoric has been pretty clear. These are common sense-led reforms. We're going to save £4.7 billion, admittedly over the course of 10 years, and it's more business-friendly than what we've got at the moment. So I did a first sort of high-level read of just to get my head around what's the basic way it works. And quite a lot of the initial theme that I took away was you've got a set of recitals that are moved into the main body of the text. As one of the participants in the report committee hearing said, it gives recitals main text credibility. So if you didn't know that legitimate interests may be a good lawful basis for doing marketing, that's recital 47, this bill makes it clearer. And it says helpful stuff that come from recitals again, if you're doing scientific research. Exactly what is it? Because there's no definition of that, and so on. The other way that the bill makes things clearer is it just changes the names of things. So if the bill becomes law, and it seems pretty likely it will, we won't have DPIAs anymore. We'll have assessment of high-risk processing. We won't have DPOs anymore, or BDPOs. We will have SRIs, senior responsible individuals. And I guess if you get your letters mixed up, you'll be calling your DPO Sir instead of SRI, which would be a bit weird. And then a standout one, I think, the existing test that we have for refusing a subject access request. It's manifestly unfounded or excessive. So manifestly unfounded or excessive, that's Article 12.5, becomes vexatious or excessive. Now, I'm not proud of my initial reaction. Regardez mon visage. There must be more to this than I am reading. And of course, I've given you cheap laughs, because that's what I like doing. But of course, subject access is more complicated than that, and it is absolutely understandable that the bill sees that there are issues with it. I'm looking for anyone who wants to put their hand up and say that the existing subject access regime is really good. It's got problems. It's open to abuse. We know it's used for pre-action litigation, disclosure by employees. A certain sort of oligarch uses it for so-called strategic litigation against public participation, or so-called SLAPP lawsuits. It has problems. On the other hand, it is a foundational right, and without it, quite hard to exercise your other rights. And as we've heard from other speakers this evening, we are on the cusp of some really, we're already living, some really amazing technologies that we've been hearing about. So subject access is a really important right. And as I read about it and what the government is proposing, about half of the new factors, it's the recital stuff for refusing a subject access request. You can sort of work it out from guidance and so forth. But it's also introducing new factors. you can start looking as a data controller at the nature of the request, whatever that means, the relationship between the subject and the data controller, the resources available to the controller. So I thought, okay, all right, I've got the gist of this. I'm going to read a bit more into a different aspect. Another foundational one is what I picked, legitimate interest. So have a listen to this. This is an exchange in the committee stage, and if you just indulge me, this is an exchange between one of the MPs on the committee and the Commissioner, and so Damian Collins. The bill uses a broader definition of recognised legitimate interest for data controllers. How do you think the regime will change for businesses? What sort of things might they argue they should be able to do under the bill that they can't do now? And this is the Commissioner. There's an argument that there's nothing under the bill that they can't do now, but it does respond to a perception that there's a lack of clarity about the scope of legitimate interest. And it's a legitimate activity of lawmakers to respond to those perceptions. The provision will allow doubt to be taken out of the economy in respect of aspects such as, is maintaining the security of my system a legitimate interest in using data? Uncertainty in law is very efficient. It causes people to seek legal opinions. And we have a role in giving greater efficiency in regulation. That's what we do at the Commissioner's Office, and you as lawmakers have just as important a role. It goes on like this, and Damian Collins asks, how would you define that clarity that the bill is seeking? If a data controller thinks, well, I have legitimate business interests, I can make an excuse for doing whatever I like, that surely isn't what the bill intends. How would you define the clarity that you say the bill seeks? The Commissioner, you're right, is the controller's assessment, and they're entitled to make that assessment, but they need to be able to justify and be accountable for it. If we investigate a matter where a legitimate interest is asserted, we would be able to test that. How would you test it? Well, through the normal process of investigation, in the same way as we do now. We would ask whether this was in the reasonable contemplation of the individual who's contributed their data as a necessary adjunct to the primary business activity that's being undertaken. So does this change things very much? It sounds like you're saying that business may assert it has a legitimate interest, but if you think it doesn't, you can investigate and take action as the law stands currently, effectively. I'm not proud of my reaction to this either. But yeah, but no, but yeah, but no. There has to be more to it than this. And so I looked, and I thought, in all fairness to the Commissioner, he is trying to tread the line in committee by making encouraging noises about the new bill, and on the other hand, acknowledging that business as usual will in all likelihood continue, and he's got some new guidance coming on vexatiousness in subject access requests. What he didn't say, and in fairness to him again, he wasn't asked, is actually the list. What the bill does is introduces a list of recognised legitimate interests, much narrower than what the government originally set out. The list itself is not all that exciting. It's quite simple and finite in number. But that concept is actually quite new in our law. A recognised list of legitimate interests doesn't require a balancing test. And it would have been very interesting to hear him say, actually, this is a much more radical thing that is happening in our law, and calling it a legitimate interest is perhaps a bit misleading. It doesn't have a balancing test in it. It's just a list. And at that point, of course, it's important to point out that you can add to the list only through parliamentary debate. So in other words, you have an affirmative resolution procedure. But it creates the groundwork for Parliament just to make new grounds of processing in addition to the 6, in effect, that we have. So at this point, our paths diverge because I thought I would love, actually, to unpack some more of what is going on in the bill, but I thought we don't have time for that. What I would do instead is just try and bring together these are personal reactions to reading this, and just think about the rhetoric that we've heard about it and what it does. The government, of course, has to tread a very fine line. On one hand, it wants to say that this is what national sovereignty can bring us. This is what freedom looks like in legislating. Look at it, it's good. And on the other, of course, good old adequacy. As we all know, the further that we depart, the harder things go in terms of that adequacy decision that comes along in about 2 years' time from our friends in the EU. So I thought, okay, it's complicated, and I thought about the 4.7 billion savings that we're making from some of these changes. I could go on about this, but I'm not going to. It's a lot of money. It's a whole lot of money. And I thought maybe I've misread some of these provisions. Maybe actually unscrupulous data controllers have got lots more leeway with those subject access requests than we thought. Actually, there's going to be lots more guidance needed as far as I can see. And I started thinking about the things that I like about the existing legislation and what the new legislation does to it. And I did promise you a third visual clue to my feelings about it, and then I'm going to be rushed off the stage because I'm going over time. Of course, there's blank faces, which is what I expected. I looked up the guest list, obviously. You're a discerning audience, but only a few of you are Fleabag fans. I can see that. It doesn't matter. I've chosen British comedians, obviously. I'll have to do that to stay on theme. But actually, so this is, for those of you who don't know, this is Harry. He's the boyfriend in Fleabag. It's a television series. Fleabag is his girlfriend. And there's something a bit wrong about Harry. Harry is drama. He's too much drama, unnecessary drama. But we do also warm to Harry. There's something likable about him. And that's when it dawned on me. He does actually encapsulate what I think about the existing legislation and the perils of tampering with it, with this new bill. And he says immortal lines like, "Don't make me hate you. Loving you is painful enough." Which puts it perfectly. Fortunately, it's time for Dan and the metaverse. Thank you very much.